Hi, my name is Brad Fouraker and I'm a practicing ophthalmologist in Brandon, Florida. I'm also a board member of OMIC, the Ophthalmic Mutual Insurance Company. And I want to talk to you today about something that certainly concerns all of us who are practitioners, and that is a malpractice lawsuit. Of course, we have to have competence and confidence in what occurs when one of these malpractice lawsuits hits. And that's the reason I want to talk to you about what is the reaction of the individual, what's the reaction of the insurance company, and how do we handle these particular situations when the claims department of an insurance carrier is called into action. Remember, a claim is a written notice or demand for money. There can be potential claims where you get a call from a patient threatening, or you get a call from an attorney threatening. But a claim is actually a written demand or notice for money. Two different things. When either of these occur, though, it's important for you to call OMIC to notify them. Even if it's just a potential claim, these are important issues. What is the normal initial response to a claim, a written demand for money? The initial response by almost any of us, if we have any sensibility, is panic. We're worried. What happened? Why is this here? What occurred? The next thing is frequently you get angry. We're all here to try to help patients. We're all here to do our absolute best for patients. It may not always turn out that way. That's the reason this is in fact an art, not a science, entirely. Now we apply our science, but things do happen. Each individual is unique. So our next inclination, just emotionally, is to become angry about the situation. Maybe even to become angry against the patient. And to become somewhat defensive. We have that fight or flight response, which is, again, very normal. Unfortunately, over time, sometimes a depression will set in. So it's important to recognize that as being a potential complication and to deal with that. And of course, your malpractice carrier, in this case OMIC, is there to help you. Now, there are some things that I would try to keep in mind. First of all, almost everybody will have a claim against them during their career. Only 5% of ophthalmologists never have a claim against them in their typical 35-year career. 50% of ophthalmologists will have 3 or more claims during their career. Only 20% though of claims end up resulting in some type of payment. And it's important to remember that in only 8% of the time when there is in fact a trial and it goes through the entire trial to a jury, only in a very few occasions will the jury rule against the physician. 8% of the time, hardly at all. So what happens when you have a claim? Who do you turn to? Who do you talk to? Obviously, our first reaction is to look at the record and to go talk to a partner or a colleague or somebody that's knowledgeable in the particular field who can give us advice, who can look over, can give us some reassurance that what we did was correct, or that we've handled things in an appropriate manner. And so we are going out seeking opinions, seeking some support in these particular cases. The problem with that is that all of these people can be deposed. So whatever you tell them, whatever you say to them, could end up being part of a deposition and end up in the trial. So you have to be very careful about those types of things, and in fact you should avoid those. Sometimes individuals, and certainly I have been contacted by subsequent treaters, who will call and say, geez, you know, you saw Miss Jones is suing me. What did you tell her? Couldn't you change your record to reflect this or that? And the answer is no, and you shouldn't even discuss the case with them. Again, there are potential problems at depositions if this kind of thing occurs. So who should you call? How should you get some support? You're in a panic. Call your malpractice carrier. That's the most important thing to do initially. Your malpractice carrier, in fact, in this case, OMIC, has 26 years of handling only ophthalmologic claims. They understand what's going on. They understand the problems that might occur. And their competence should give you confidence. At that time, you're looking for someone to give you some reassurance that what you did was right or wrong. You're also depending upon that insurance carrier to listen to your story, to listen to what occurred, and to ask you the appropriate questions. Because of their longevity in the field, they understand the types of things that must be asked, the types of things that are important in a particular lawsuit, ways to protect yourself. They also need to understand if there are other individuals that are involved in the particular lawsuit. Again, all of this should give you some comfort because at that particular time, you may not be considering all of the various issues, but they're displaced from this somewhat and that they're representing you. They're representing your best interest. And in that case, they simply want to ask the questions and try to guide you in a direction to help you through these difficult periods. It is important for you to review the medical record. Obviously, you won't necessarily know the care that was provided. But one of the things that's particularly important is don't alter the medical record. It is absolutely fatal to a defense if you alter a medical record, even in the smallest way. You may see something in the record that you know you did and you simply didn't document it. You have a tendency to want to add that into the record. Don't do it. You may see something in the medical record that doesn't necessarily reflect exactly what you saw on a particular day, and you remember exactly what you saw, and you want to add that or alter that or change that. My advice is do not alter that medical record. I'm going to provide you with a case study of one of the issues that we had at OMIC, and this case will demonstrate why it's important not to change a medical record. In November of 2000, a cataract surgeon referred a patient over to a retinal specialist with visual distortion in the right eye after cataract surgery. The vision was 20/30 in the right eye at that particular time, but the retinal specialist noticed there was some macular pucker and an epiretinal membrane, confirmed both by fluorescein angiogram and fundus photography. The retina specialist went on to call the family, to call the patient and her husband, and explain the findings, and explain the risks, the benefits, and the alternatives to going in and doing a vitrectomy and trying to improve the visual acuity. The patient did agree with going ahead with surgery, and in fact, the surgery was performed quite successfully. But postoperatively, by January of 2001, the patient's vision had in fact started to decrease somewhat. And by March, the vision had decreased to only 2400 in the right eye. And there was obviously some mild atrophy in the temporal portion of the optic nerve. By May of 2001, the vision was still 2400, and she was diagnosed as having a small vascular accident in the perioperative period. The plaintiff decided several months later, in July of 2001, to go seek a second opinion from another retinal specialist and another neuro-ophthalmologist and requested that the records be sent to those individuals. And they were sent in July of 2001 to those individuals. The original retinal specialist, the plaintiff in this, the defendant in this particular case, got some wind that there may be a malpractice suit filed. So in April of 2002, he became somewhat concerned about this, and in fact, in November of 2002, was notified that there was a lawsuit filed for the care that was given. It should be noted that the patient's husband was an attorney in this particular case. These records were sent, the physician's records were sent to OMIC for review. OMIC then sent these records out to be reviewed by experts in the field, board members, committee members, who would give confidential advice regarding the care that was provided. A review was done and found that actually the care that was provided was perfectly appropriate. It certainly met the standard of care for the community. It was not below this standard of care. It was excellent care overall. And in fact, that the damage that occurred is a complication, or could potentially be a complication for the surgery, but maybe not even. The plaintiff in this particular case, the patient's expert, looked at the same records and said, it appears everything was done perfectly fine. The only criticism I have is there is no apparent explanation of the risks, the benefits, and the particular alternatives to this particular treatment that are given in the medical record. I see no notation of that. But when the physician's deposition, the insured's deposition was given, the insured said, I wrote out and I provided to the patient an explanation of the risks, the benefits, and the alternatives completely at the time. When the plaintiff's expert had the deposition taken, the plaintiff's expert said, I don't see anything in the medical records indicating that the risk, benefits, and alternatives were provided. I don't see an appropriate consent in here. And in fact, that's when the bells went off. And the attorney for the physician that was having the action brought against him asked for a copy of the medical records, and they went and examined those records. It was at that time that the physician that was the defendant in this particular case indicated that I heard there was going to be a lawsuit in 2002. I went back because I remembered that I gave the risk, benefits, and alternatives explanation, and I added that into the medical record at that particular time. Didn't date it, didn't indicate they had done it after the period of time, but just left it in there. Well, of course, now you have a set of medical records which had been sent previously to the other retinal physician, the other neuro-ophthalmologist, not showing any explanation. You have the altered records of the physician who's trying to defend himself in this particular case, and the two don't match. Well, who's a jury going to believe? Typically, a jury is there to believe the physician. They believe that physicians are good people, highly trained people who are there to try to help and trying to do the right thing. In this particular case, though, there's an alteration in the medical record. So the confidence that the jury would have to the physician is gone at that particular time. They now look at that physician and view him as being someone who's unreliable, who's not honest, who doesn't tell the truth. So they're going to actually lean toward, in this particular case, the plaintiff's side. It was estimated by the defense attorney that if this goes through if this had gone through an entire trial, the jury would have awarded about $350,000 to the plaintiff. So a settlement was reached for $50,000 in this particular case. So you have in this case a physician who has done all the right things as far as providing the treatment to the patient, doing the right thing with the patient, trying to help the patient any way they can, but they altered the medical record. And because of the alteration in the medical record, even though the care was absolutely fine, there had to be a payment made in this particular case. So jurors will sit through hours of testimony, conflicting testimony at times. But when they go back to the jury room, they're going to have the copies of the two medical records, and they're going to consider that there's been some dishonesty that has occurred in these particular cases, and are going to rule, in fact, if there has been an alteration in the medical records, likely in the case of the plaintiff and not the defense. So if the integrity of the medical record is compromised, then you're likely going to lose the case in almost any of these cases. Even if you alter it just a little bit, even if you're there just to try to clarify something, even if you're just trying to add something in that you know occurred and you have the best of intentions, don't alter the medical record in any way at that particular case. Now, are there ways to correct a medical record before something like this happens? Well, let's talk about a medical record. Medical records obviously are the main evidence to either criticize or defend the ophthalmologist's actions and decision-making process. They are a legal business record. They should have credibility, they should have some integrity. They're presumed to be reliable, that you've added in, the expectation is you've added in your thoughts at the time, and you've added in your best thought process at that particular time. And they are absolutely critical to the defense of a physician to show what was done, what was not done, what the thinking process is. Now, there are some legal issues with paper records. One would be, obviously, illegible handwriting. If you can't read the record, well, that becomes a problem. In addition, there could be lack of documentation. You may have thought about something, but if you don't write it down, you didn't do it. We've all heard about this from medical school for many, many years. There can be untimely entries, such as the one I just talked about. Now, you can add in later on a thought, but can any of us really say that we remember what we did with the patient 6 months or a year later? It's possible, but it's unlikely that you remember with that kind of distinctiveness that you want to add that back into the medical record. Sometimes you do, but it's unusual. That brings into the idea of questionable accuracy of them. And of course, we all have to be careful of predictated operative notes, which are not uncommon. What makes for a good written medical record? It should be legible. It should be well organized. It should be very accurate. You don't want to have a lot of errors in there. It should be as complete as you possibly can. Now, none of us can obviously put everything in a record that we would like. Otherwise, we would be seeing one patient a day. It wouldn't be of much service to anybody. But as much as you can, try to be complete. The records should be timely. They should be signed. And if you're going to change a medical record, do it in an appropriate way. So if you have a paper medical record, it's perfectly appropriate to draw a single line through an error, date it, initial it, and then make the obvious appropriate changes that need to occur to correct an erroneous material inside a medical record. Now, what about electronic health records? That's obviously a whole new thing. You don't want to draw through your electronic health record. If you do that, you're going to have a messy screen. So you won't be able to do that very often. So with an EHR, the advantage they have is they're very legible. In fact, maybe too legible. They can be very well organized. They can be accessed from a number of locations, which can be a big advantage if you're at home and you're called for an emergency. But they do tend to slow down productivity. So in response to that, many of us use functions such as copy forward, copy and paste. We use defaults, we use templates, which are pre-populated screens. But these can all, unfortunately, lead to outdated data, outdated material. I cannot tell you how many times I've seen records where a patient has gone through a cataract extraction, and yet on the medical record it shows they still have the cataract. Obviously, that can't occur, and that makes for a very messy medical record. Drop-down templates can be of tremendous benefit, but it's a lot of information. And if you don't go through all that information carefully and sort out really what's true, then you could be putting erroneous material in the medical record. Drop-down menus, the same basic problem. Again, there's so much material there, there's so much pre-printed information there, that sometimes it's hard to see exactly what you want. And electronic medical records, we have to have ones that are concise. Obviously, if you have an electronic medical record which is voluminous, it's not that much help to anybody. Let me give you another example. There was a patient, and this came to OMEC as a claim. There is a patient who had cataract surgery in the left eye and had 20/50 vision post-operatively after a 1-week period of time. 3 weeks later, though, unfortunately, the vision had dropped to 21/50. 2 months later, it dropped to only hand motion. During that period of time, the medical record indicated there was an anterior chamber reaction. Yet, despite that, the use of Pred Forte was constantly being reduced. The fundus examination was noted as being normal, and it wasn't until a week after the 2-month exam that the patient was noted to have, in the diagnosis, retinal vasculitis. But again, if you looked at the medical record of the actual fundus exam, it was noted as being normal. The patient, though, was sent to a retinal specialist. The retinal specialist agreed there was some vasculitis, agreed there was some uveitis, agreed that all that accounted for the decreasing visual acuity. But you can see the contradiction inside the medical record, which would create some doubt among juries and other individuals. You have an individual who has cell and flare noted on his medical record and at the same time is discontinuing steroid drops. And of course, during deposition, the physician said, I would have never stopped the steroid drops unless the anterior chamber was in fact becoming more and more quiet. And in addition to that, I would have never sent the patient to a retinal specialist, nor noted in the findings of the particular case that there is vasculitis if there was a normal fundus exam. But ultimately, the fundus exam did say it was normal. Again, the medical records are a reflection of your ability to give care. If the medical records are sloppy, it's presumed you're sloppy. If the medical records are inaccurate, it's assumed that you're inaccurate. So for better or for worse, they were a reflection of us as physicians. They're a reflection of how we provide care. And if they're inaccurate, they're sloppy, if they're having difficulties, that's a reflection on the care that we're providing. So be careful about the copy forward issues. That's what happened in this particular case. The lawsuit itself finally ended with a decision for settlement for $290,000 against the physician. And a lot of it hinged on the fact that the medical records were so bad and they were so inaccurate. Now, can you change a medical record that's electronic? Of course you can. But there is an audit trail, so any change you made can be found. So if you alter the medical record, date it, indicate why you've changed it, put the appropriate information in. But if you go back and simply change it without any other notification, realize that that can be found out in an audit trail. It's also important to provide a medical record which is appropriate, one that provides accurate information. I recently spoke with a rheumatologist, a colleague of mine, and in fact this was just a couple of days ago, and he indicated at the time that he had a number of patients who had large swollen right knees. He'd had a series of them. He'd sent them all over to an orthopedic specialist that we're all very familiar with, and was getting back these 12 and 14 page reports from the individual. In those 12 and 14 page reports, it told all about the patient's smoking history and the attempts that could be made to stop smoking, despite the fact that the patient never did smoke. But if they did smoke, there's a whole half page saying how they would end up avoiding further smoking with that patient. There was plenty about the patient's family history, none of which was relevant. But when it came down to the diagnoses, to saying exactly what the patient had, there's no information. In addition, there was no opportunity to say how one would treat that patient. All of us have had these medical records that have come to us. They're not very helpful. They're not very useful. They're not a good reflection of you as a professional. And they don't help, it does not help when we have to go to the patient and say to the patient, what was it that that consultant told you? That's what the medical record should show. So, in summary, it's important that if you have a medical malpractice case against you, that you feel comfortable with your medical malpractice carrier, someone who specializes in your field, someone who understands what's going on, and that you have not a panic reaction, but a secure reaction because you've been able to contact a professional and a group of professionals who can help support you, can help guide you, can help you in these particular situations which are awful for all of us. And it's in having that security that you want to make sure that your malpractice carrier has an understanding of what's going on, because many times you're somewhat panicked, you're trying to give the information at a mile a minute. Thank you very much.